I let you out the last time, should have of all rights locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? I end up, you get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand it. When I get out this situation this time, I'm by myself.
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on a $100,000 cash bond, and you're about to go now.
Honorable Carter, David Burgess, on behalf of Mr. Carter.
Mal Carter.
Thank you.
Chris Clare on behalf of probation. Your Honor, Mr. Carter is before the court for an adjourned violation of probation. Carter, when he was last before the court, did have a pending felony case. The court did arraign him on that bench warrant. He was set for court. That case that is pending is now set for appeal on November 5th. Mr. Carter now has another new pending case, a domestic violence second offense, and it interfered with communications with an alleged date of offense of October 20th, 2024. He is on bench warrant status in that case. Given that there has been continued alleged assaultive behavior with the added victim in this case, because the court did add a no contact with that victim, it does make it a violation of this case. Probation's asking that the court, one, address the felony warrant on that 2-4-FB case. If the court does have it, that the court revoke probation and sentence Mr. Carter to jail 365 days, credit for 162 days served to serve the balance, that he complete the jail DV program, waive remaining terms, accepting his financial obligations, and discharge him from probation without improvement.
Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case. However,
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. We're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honors, indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's on what's it? He's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they have contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer was speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the scope of probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation about the probation and sentence the defendant to serve balance at this time. And in bond in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana, that the defendant will submit to random drug test when requested. He's not to leave the state of Michigan without permission of the court. You're not to possess, purchase any firearm, ammunition, or other dangerous weapon. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are to have no contact with Jennifer Matlock except by a civil standby with the police. You cannot have any direct or indirect contact with the above named person, Ms. Matlock, in person or through others or by electronic communication, including but not limited to phone, email, texting, internet, social media, or refer to the person listed online in any form whatsoever. You are not to go to I have a location at 1265 Russell Street.
I'll check that, Your Honor, while you continue and double check that that's correct.
You are not to go to that location except with civil standby with the police. If this is your home address, you must find another place to live and notify the court of your new address within 24 hours of any release from incarceration. You are not to violate any criminal law. You are to personally appear at all court hearings and other places as directed by the court. You understand all of those conditions?
Yes, sir.
And Your Honor, that address is the location where the incident took place. Did we also ask the defendant be prohibited from going to a Glencoe Hills address? I can give the court whenever it's ready.
Yes, go ahead.
2255. Well, actually, we can request the Glencoe Hills apartment complex in general, specifically 2252 Glencoe Hills Drive in Ypsilanti.
2252. Better, I'm not entirely sure what is going on with you in that regard.
Not litigated.
I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't, but
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
Simpson, can I say something?
You can say whatever you want.
I understand. Just she put up on me. I was in the room playing my game, and she came in the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car and that's when I pulled off.
Well, maybe that's all going to come out, Mr.
I understand.
Carter. Maybe that's all going to come out. I let you out the last time. Should have of all rights locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand. I take
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I post sentence on that case?
I want to say I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. You understand it. When I get out this situation this time, I'm be by myself. I just know.
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Don Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in jail DV program.
Thank you.
Is what I meant to say.
Thank you.
Thank you. Defendant's remanded.
Okay.
That's not before me. He's got to do it in circuit court. Court calls the case People versus Maurice Couchman.
After one for the people. Couchman, please state your name.
Maurice Koshman.
Okay.
Teresa Claire on behalf of probation. Your Honor, it's my understanding that the victim in this case, Alyssa Chamberlain, should be present via Zoom.
Alyssa Chamberlain.
Yeah, I'm here.
Okay. Yes, she's here.
So, Your Honor, it's my understanding that Ms. Chamberlain would like to address the court to request the court lifting the contact order. The court want to address that first, or my recommendation for Mr. Couchman?
Either way, go ahead with you.
Okay, so as to Mr. Couchman's recommendation, he is compliant with the terms ordered by the court. I did make his appearance, however, he is present today. Probation is recommending that all conditions continue as previously ordered, with the next review hearing being set February 10th, 2025 at 1 p.m.
Sir, anything you want to say?
I know she wants to take the order away or whatever. I want to keep it.
Okay, so hold on. Ms. Chamberlain?
Yes, sir.
All right, do you have a camera?
Yeah, you want me to turn it on?
Yes.
Okay. Hello.
Hello.
Hi.
All right. What did you want to tell me?
I just wanted it lifted because I've been in contact with his mom to see our son Leo, and she hasn't really been compliant with it.
You've
the
been in
last-
contact with whom?
With Maurice's mom.
Okay.
And she hasn't really stuck to her things or anything like that. The last time I was supposed to pick Leo up, she completely ghosted me. So I was just hoping to maybe lift the no contact order to just talk to Maurice directly. But just about our son.
Okay. And thank you. And you have a problem with that?
Yes, sir. Yes,
All
sir.
right. Hang on before you go.
People would be opposed to any change in the no contact order this time.
All right.
It's my understanding from probation that probation, I don't know if you're taking a position or not, but people wouldn't be opposed to it.
All right. Sir, what did you want to tell me?
I just want to keep it like it is, no contact.
You want to keep the no contact in place?
Yes, Your Honor, because I don't know if you were been told, but there was an incident a couple weeks ago. Her and her mother came to my house, and basically how I have it set up is my mom is supposed to make contact with her, and the last time she tried to make contact, she said she was going to pick the kid up at 4. She never picked my son up. She just ignored my mom. Alyssa
Okay.
Chamberlain.
Okay.
So,
go ahead.
she came to my house.
Who did? When you
Alyssa
keep saying
Chamberlain.
she,
I'm
I'm just trying
sorry.
to. It's okay.
Alyssa Chamberlain is just
Right.
nerve-wracking. Alyssa Chamberlain came to my house with her mother with the no contact. She's not supposed to be around me. I told her that. I called the police and made a police report. There's no reason for her to talk.
Okay. So hold on a second. So, because I just want to make sure I understand. The arrangement was set up that your mother would act as a go-between, basically.
Yes,
Is that right?
yes.
Okay. And then for whatever reason, something happened where you're claiming Ms. Chamberlain did not get the child from your mother. Is that right?
Yep.
And then 2 weeks ago, you're saying thereabouts,
Yeah.
that Miss Chamberlain and her mother
Yes.
show up at your house
Yes, Your Honor.
and that you ended up calling the police.
Yes, Your Honor.
At this point, the hearing takes a very different turn. Instead of focusing on whether the original offense occurred, the judge is now trying to determine whether the existing no-contact order is still protecting everyone involved or creating even more confusion. Courts don't issue no-contact orders simply to keep people apart. They're designed to prevent new allegations, protect the integrity of the case, and avoid situations where emotions can quickly escalate. What's interesting here is that both sides agree they need to communicate about their child, but they completely disagree on how that communication should happen. The defendant says the order worked because he called the police instead of engaging. The alleged victim says she didn't even know the order existed and only wanted to coordinate parenting. So, here's the question. If children are involved, should courts make exceptions for communication, or is keeping strict boundaries the safest option? Let us know where you stand.
Ms. Chamberlain, is all of that correct?
So kind of, it was me and my aunt, and we did show up at his mom's house. But at this point, I didn't know that me and Maurice had a no contact order. I wasn't aware of any of this. I moved and didn't receive any paperwork. I changed my number, so I wasn't receiving any calls or anything. So what happened
What do you
was,
mean? What do you mean that you didn't know?
I didn't know there was a no contact order.
So
I didn't even know Maurice got in trouble.
Hold on. So why do you think you were why was his mother then acting as a go-between?
I just thought he didn't want to talk to me.
Okay. So it sounds like he still doesn't want to.
That's okay, but we need to figure something out to where his mom answers the phone and sticks to her stuff when I'm supposed to pick our son up.
Okay. So I'm going to assume that the mom, his mom,
Yes, sir.
I take care of.
hold on. That she's a full-grown woman, and so are you, right?
Yes.
So it seems like for your son, her grandchild, that the two of you could talk to try to work out whatever you guys want to work, and that Maurice doesn't necessarily have to be a part of that, does he?
I mean, no, and it wasn't a problem until the last time when I was trying to get Leo. She told me I could get him, and I confirmed it the day before and then completely ignored me. So then that's when me and my aunt went to her house to try to talk to her. I didn't know Maurice lived there.
Okay. So here's what I'm going to do, because there's obviously something else. I'm not entirely clear what's going on, but if he got into a circumstance where he had to call the police, then that circumstance can't happen. So I don't know what is going on, and you guys as parents need to figure this out for your son, quite frankly. But as between the two of you, if he doesn't want to have contact, I'm not going to force him to have contact. I mean, he's relying upon the court's order, and he did, quite frankly, given the other hearing I had today, he did exactly what he was supposed to do when you showed up. He wasn't trying to do anything. He called the police because he's the one under the jurisdiction of the court. But if he doesn't want that, I'm not going to change anything.
Okay.
And for the record, Your Honor, I asked probation if there was currently a circuit court order regarding parenting, and there is not. And the defendant has custody of the child this time.
Who does?
The defendant.
You have custody.
Yes.
I do not have legal custody, but I've been taking care of my son for the last 8 months, taking him back and forth to school, everything.
Okay.
So
I'm just being.
No, I got you.
now you're giving anyone legal advice about what to do, but
well, somebody's going to have to figure. Yeah, you guys are going to have to figure something else out. But, ma'am, Mr. Couchman does not want contact with you directly. So I'm not going to place him in a position where he has to do that, because obviously he's maybe through this process learned something. So I'm just going to leave everything where it is. I'll continue all of your, Mr. Couchman, I'll continue all of your previous terms as ordered.
This hearing ended with the judge choosing stability over convenience rather than lifting the no contact order. The court kept every existing condition in place after concluding that the defendant had actually followed the order by avoiding direct contact and calling law enforcement when the situation unexpectedly escalated. The judge also recognized that there are unresolved parenting issues, but made it clear those questions belong in the proper family court process, not by weakening a criminal court order that's already in effect. The defendant remains compliant with probation. His conditions continue unchanged, and the next review hearing has been scheduled. It's a reminder that criminal courts focus first on public safety and compliance with court orders, while custody and parenting disputes are handled separately. If this courtroom moment gave you a new perspective on how judges balance legal protections with real-life family complications, be sure to hit that like button, drop your opinion in the comments, share this video with someone interested in courtroom cases, and subscribe for more authentic legal breakdowns and unforgettable hearings.